On April 29, 2026, the ATF signed the largest single-day firearms regulatory action in its entire history, 34 separate rules touching everything from pistol braces to suppressor paperwork to how the agency classifies bizarre edge case devices that have confused gun owners and even federal judges for years. But understanding why this happened right now, in this specific way, requires understanding a Supreme Court case most gun owners have never heard of, one that had nothing to do with firearms at all. Most coverage of this reform package treated it as a straightforward political story, a new administration loosening rules it disagreed with, without ever explaining the deeper legal mechanics that made the timing, the scale, and the specific targets of this package make sense. I'm going to walk you through the legal earthquake that made this reform package possible, the specific classification absurdities that pushed federal courts to start openly criticizing the ATF, and what this 34-rule package actually does versus what's still just a proposal sitting in a 90-day comment period. Before we get into it, if you want to understand the actual legal mechanics behind a regulatory shakeup this large, not just the surface-level headline, subscribe and turn on notifications right now. This is exactly the kind of story where the backstory explains everything about why it happened when it did, and understanding that backstory is what lets you predict how the remaining 27 proposed rules are likely to shake out. Let's get into exactly what changed and why. Here is the legal earthquake you need to understand first, because nothing about this reform package makes sense without it. In 2024, the Supreme Court decided a case called Loper Bright Enterprises versus Raimondo, overturning a 40-year-old legal doctrine known as Chevron deference. Under the old Chevron framework, when a federal statute was ambiguous, courts were required to defer to a federal agency's own reasonable interpretation of that statute, giving agencies like the ATF enormous latitude to interpret gun laws expansively without much risk of being overruled by a judge who might read the statute differently. Loper Bright eliminated that deference entirely, instructing courts to use their own independent judgment when interpreting statutes rather than automatically siding with whatever interpretation the agency itself preferred. That single ruling fundamentally changed the risk calculation for every federal agency issuing regulations based on ambiguous statutory language and the ATF, which has spent decades interpreting terms like firearm, silencer, and destructive device in ways that often stretch the statutory text considerably, suddenly found itself far more exposed to losing in court. The first segment of this story is what that exposure actually looked like in practice, because federal courts didn't wait long to start applying this new, less deferential standard specifically to ATF classifications. In multiple cases following Loper Bright, federal judges began openly criticizing the agency's approach to classifying firearms and accessories, with one federal court describing the ATF's practice as attempting to fit a square peg into a round hole, overclassifying certain devices as regulated NFA items, even when they plainly didn't meet the statutory criteria Congress had actually written. This wasn't an isolated complaint. The ATF has a long documented history of issuing classification rulings on genuinely strange edge cases, muzzle brakes, barrel shrouds, devices that alter rate of fire, and less lethal launchers loaded with everything from rubber pellets to beanbags to paint-based marking rounds, sometimes reaching conclusions that struck outside observers, including judges, as inconsistent from one ruling to the next. A 1995 ATF ruling, for example, classified certain 37mm gas and flare launchers as destructive devices, specifically when loaded with particular less lethal anti-personnel rounds, a classification that made sense to the agency internally, but left manufacturers and gun owners struggling to predict how the ATF would treat similar, but not identical devices without submitting a formal request and waiting, sometimes for years, for an answer. Separately, the agency has issued a whole body of individual rulings over the decades addressing devices attached to paintball markers specifically, at one point concluding that a suppressor built exclusively for a paintball gun still counted as a regulated NFA firearm muffler in its own right, entirely independent of whether the underlying paintball gun itself was regulated at all. an outcome that struck many observers as a genuinely strange, hyper-technical reading of the statute that had far more to do with how the agency chose to parse individual words than with any coherent underlying safety rationale. The second segment is why this pattern of unpredictable, after-the-fact classification became a much bigger legal liability for the agency once Chevron deference disappeared. Before Loper Bright, if a manufacturer or gun owner challenged one of these classifications in court, judges were generally required to defer to the ATF's reasoning as long as it was a reasonable interpretation of an ambiguous statute, even if the judge personally might have read the law differently. After Loper Bright, judges started applying their own independent reading of the actual statutory text, and several ATF classifications that had survived for years specifically because of Chevron deference began losing in court once that protective shield was gone. The pistol brace rule, which attempted to reclassify a huge range of stabilizing braces as effectively converting pistols into short-barreled rifles, became one of the most prominent casualties of this shift, with multiple federal courts, including within the Fifth Circuit, finding the rule violated the Administrative Procedure Act and issuing injunctions that left it largely unenforceable for years even before it was formally rescinded. The third segment is what Director Robert Sakata actually announced on April 29th, and the scale genuinely matters here. The 34 rule package arrived roughly 2 hours after the Senate confirmed Sakata as ATF director, timed deliberately to coincide with his confirmation, and was signed jointly with Acting Attorney General Todd Blanche under Executive Order 14206, titled Protecting Second Amendment Rights. The package organized its 34 actions into 5 categories: repeal, modernize, reduce burden, clarify, and align, mixing final rules that took effect immediately, direct and interim final rules with varying implementation timelines, and proposed rules still subject to public comment. 33 of the 34 rules touched firearms specifically, with 1 covering explosives, making this, by the agency's own description and independent industry analysis, the largest single regulatory release in ATF history. The fourth segment is what the package actually repealed outright, because this is where the post-Loper Bright legal pressure shows up most directly. The package formally rescinded the 2023 pistol brace rule, removing the specific regulatory language that multiple courts had already found unenforceable, and restored definitions more closely tied to the underlying statutory text Congress actually wrote. It also stripped bump stock language from the federal machine gun definition, aligning ATF regulations with the Supreme Court's 2024 ruling in Garland v. Cargill, which had already found the agency's bump stock classification exceeded what the statute actually authorized. The package eliminated the requirement to notify a local chief law enforcement officer when filing certain NFA paperwork, and replaced an indefinite records retention requirement for Form 4473 with a defined 20 to 30-year window instead. Each of these repeals targets exactly the kind of expansive, agency-driven interpretation that Chevron deference used to protect, and that Loper Bright left considerably more vulnerable to being overturned in court. The fifth segment is what the package deliberately left out, because understanding the gaps matters just as much as understanding what's included. Frame and receiver regulations, one of the most contested and heavily litigated areas of ATF policy in recent years, were not part of this package at all, a gap several industry analysts described as glaring and almost certainly deliberate, likely reflecting either ongoing litigation the agency doesn't want to complicate, or a decision to handle that specific fight separately, given how much independent legal attention it's already receiving in the courts. Suppressor classification under the underlying 1934 NFA framework itself, something industry groups like the National Shooting Sports Foundation have pushed on for years, also wasn't formally addressed in this package, even though the separate, unrelated reduction of the NFA tax to $0 for suppressors had already taken effect at the start of 2026 under different legislation entirely. The sixth segment is the important distinction between what's actually final right now and what's merely proposed, because conflating the two is exactly the kind of mistake that leads to real legal trouble. Only 7 of the 34 rules are final rules, meaning they're either already in effect or take effect immediately upon Federal Register publication. The remaining 27 are proposed rules, meaning they're subject to public comment periods running as long as 90 days into late July and beyond, and they are not binding law until that process concludes and the agency issues a final version, which could differ meaningfully from the initial proposal depending on what comments the agency receives. Let's step back and name the single thread running through this entire story. This wasn't simply a new administration deciding to loosen gun regulations because of a political preference. It was, in large part, a defensive legal response to a fundamentally changed judicial landscape, one where the ATF's traditional practice of interpreting ambiguous statutory language expansively and counting on Chevron deference to protect those interpretations in court stopped working reliably the moment the Supreme Court eliminated that deference in 2024. Federal judges calling out the agency's square peg, round hole approach to classification wasn't an isolated complaint. It was a preview of exactly how much legal exposure years of aggressive, inconsistent rulemaking had created once courts were free to apply their own independent judgment. The 34 rule package is best understood as an attempt to proactively fix, or at least paper over, years of accumulated regulatory vulnerability before more of it gets struck down piecemeal in court, case by case, over the following several years. It's worth appreciating what this reveals about how federal agencies generally respond once a major legal protection like Chevron deference disappears. Loper Bright didn't just affect the ATF. It reshaped how every federal regulatory agency has to think about the durability of its own rules, since any interpretation built primarily on the old assumption that courts would defer to the agency's expertise now faces a genuinely higher bar in litigation. Agencies across the federal government have spent the 2 years since Loper Bright quietly reviewing their own regulatory portfolios for exactly this kind of vulnerability, and the ATF's 34 rule package, arriving on Director Cicada's literal first day in office, represents one of the most visible, concentrated examples yet of an agency trying to get ahead of that exposure all at once, rather than waiting to lose case after case in scattered litigation across different circuits over the following several years. If there's one thing worth taking from this breakdown, it's that a regulatory shakeup this large rarely happens in a vacuum, and understanding the legal pressure that actually produced it tells you far more about where ATF policy goes next than the headline count of 34 rules ever could. Watch specifically for how the 27 still proposed rules evolve through their comment periods, because that process, not the initial announcement, is where the actual final shape of this reform gets determined. If this helped you understand the real story behind this reform package, share it with someone who's only seen the surface-level headline. Subscribe so you catch each of these 27 proposed rules as they move toward final status, and I will see you in the next one.